Good night and welcome to LawCall. My name is Ted Howell with Perry & Young, and we have the phone lines open. Please give us a call at 850-392-1544 or at LawCall at WMBB.com. We're going to be talking about divorce and child custody tonight. But before we get started, let's go to our first email question, please. My car was rear-ended at a yield exiting the freeway to the street. I had it for less than a month and now it's a total loss, getting nothing from my insurance, gap insurance, or the other driver's insurance. My loan is the only thing being covered. I want to fight, but I'm not sure if there's a way to help. And this is from Eva. Eva, that's a very difficult situation you have on your hands. The problem you are dealing with in this particular situation is property damage coverage. And unfortunately, a vehicle is a depreciating asset, and as soon as you drive it off the vehicle, it is not worth the amount that you paid for it on day one. And the law on property damage valuation is when it's damaged, you're entitled to recover what the fair market value of that vehicle is as of the date of the loss. Now, that will take into consideration factors such as the make, model, the wear and tear, how many miles you have on it, any upgrades or changes you've made to the vehicle. So it's a very complex process that they look through, and they look at various different valuation tools. But at the end of the day, you can only get what the vehicle's worth. The gap coverage will pay for if the value of the vehicle is less than what you owe, and it sounds like that's the situation you're dealing with because you're saying that the loan is all that's being paid off. And in that particular situation, if you did not have that gap coverage, you could end up losing your vehicle and then also having to pay in order to satisfy the loan for that remaining balance, the difference between what you owe and what the value of the vehicle is. So it's important that you have that coverage. But unfortunately, it's just a bad situation that the law only entitles you to recover actually what the value of the vehicle is. Good thing that you have that gap coverage, but unfortunately that sounds like that's all you're going to be able to recover from the property damage. If you do have bodily injuries in addition to that property damage, that's a whole different scenario, and there's all kinds of coverages both on your policy and the policy on the individual that hits you that may come into play. So make sure and give us a call so we can see if there's something we can do to help you out on that particular side of the case. So that's our little personal injury warm-up, and now I have the distinct pleasure and honor of introducing John Young Roberts here tonight, coming down all the way from Jackson County to help us out and talk a little bit about divorce and child custody. John Young, nice to have you here.
Good to be here in the big city, Ted.
I know, yeah. You come all the way down. John Young, if you would, just briefly introduce yourself to the audience.
Good evening. I'm John Young Roberts. I'm with Roberts Roberts. It's a family law firm in Marianna, Florida. And Ted is a double first cousin to me. I married his cousin and he married mine, and that's the way we do it.
That's Jackson County for you. That's all you can say about that.
I've known Ted a long time. Think a lot of you, Ted.
Yes.
Thanks for having me.
Thank you, John Young. And John Young specializes primarily in divorce, family law. What all does that entail, John Young?
You know, small town practice, we do everything from dissolution of marriage action. That's the main meat of our practice, but we do modifications of custody, child support, modifications of child support, adoption, contempt when people aren't following final judgment. So the whole gamut when it comes to family law.
I got you. And I know we were talking about this just the other night. I know there's been some recent changes in the family law arena, in particular with respect to alimony, a pretty substantial change that's just come down from Governor DeSantis' office.
Yeah, our alimony statute, it's been a challenge for quite some time. Over the past 2 decades, it's very difficult to give clients advice when it comes to alimony because, you know, judges have a lot of discretion. Some judges are very stingy with alimony and some judges are very liberal with it. Right. And so it's very difficult going into a final hearing to try to give a gauge about what the alimony claim would be. And the legislature passed bills that was vetoed twice by the prior governor, and Governor DeSantis signed this one. Yes. But at least we now have a gauge, and it did away with permanent alimony, which is something that's been in the forefront for a long period of time. And so now, and it did away with different periods of marriages. So in Florida, you have 3 types of marriages. 1 to 10 years is a short term, 10 to 20 is a moderate term marriage, and then 20 years and longer is a long term marriage. And so now we have a gauge where we say this is the max amount that could be ordered and the max amount of time, which before this passage, this new bill on July 1, we didn't have that.
Right, and I guess that helps with a little more certainty, because every judge can have their own unique look at it, and this kind of gives and limits that discretion a little bit.
That's correct, Ted.
Very good, very good. Any other recent changes that we've had that we're dealing with now that's kind of different from what the status quo was beforehand?
One of the big changes that's taking place just within the last month is there's a presumption that it should be ordered 50-50 custody or rotating custody. When I first started practicing law 22 years ago, there was a presumption in the statute that says courts shall not award 50-50 custody. It's presumed not to be in the children's best interest. In 2008, a statute was amended to take the presumption against 50-50 out, and now the legislature and the governor signed the bill that presumes that the court should award 50-50 custody in every family law case. However, it's a rebuttable presumption. It's by preponderance of the evidence, and then the courts still have a lot of discretion. But now the presumption is for equal time sharing or 50-50 custody.
I got you. So that looks at making sure the kid is with both parents as much as possible. And that's what the law is trying to promote, so that everybody has access and can have that influence, both the mother and the father.
Right.
Or I guess the mother and the father and father, depending on the situation. Remember, those phone lines are open, 850-392-1544, or you can email us at lawcall@wnbb.com. If you have a question about divorce, child custody, alimony, support, adoption, you name it, John Young's here to help us with that. If you have a question about personal injury, call and I'll answer it. If you have a question about anything, we're ready to go tonight. Because in addition to family law, John Young, I know you have a general practice as well. In addition, I know you focus primarily on that, but what other kind of areas do you see cases in on a day-to-day basis?
We do a lot of probate issues, a lot of wills, deeds, boundary line disputes, civil litigation. We kind of steer clear of personal injury law. We leave it to the experts for that.
There you go.
I hope to get a big referral fee.
That's right.
But we steer clear from doing like personal injury or bankruptcy. But in a small town, we do a little bit of everything.
Okay. I think we have a call on the line now. I think it's actually a car accident case. If you would, Reginald out of Houston County. Reginald, please proceed with your question.
Yes. I was rear-ended on the back of my car, and I was wanting to know, like, when I was hit by the car, when I called the insurance company and asked them about it, it was said on the report, the police report, that I was hit by a Ford Edge, which I was hit by a Ford Focus. But on the report, it was put on a Ford Edge. What I want to know is that some kind of like a fraud made on the report, or what can I do? Because when I called her, talked to her insurance company, they were saying she only had insurance on the Ford Edge and not the Ford Focus.
Right, and Reginald, it could be a couple of things. One, it could just be a simple mistake on the part of the officer when they actually created that report, or there could be something more sinister going on. That's why it's important that you get someone to assist you with that sooner rather than later, because at the end of the day, what the report says isn't what matters. What matters is what actually happened and what you actually experienced in that day, in that situation. As a matter of fact, even the actual crash report is not ultimately admissible in court. You have to be able to prove the facts and establish what actually happened. So we know you were rear-ended. We know what kind of vehicle it was. We need to make sure we know which insurance company that is so that you can put them on notice and pursue that claim. And so the way it would start is ultimately you would go through the claims process, see if you can resolve it that way. And if you can't, then the only next step is that you have to pursue it through the litigation system, because while it's always best to try to work something out amicably if you can, if not, that's what the courts are there for, and that's what we do, and that's what we do every day, both in Florida and Alabama, and we have partners that practice in Georgia as well. So, Reginald, we'd love to help you out with that and make sure we get those clarity on exactly which vehicle it was, which policy covers it, and make sure that you get properly compensated for what you're dealing with. Now, John Young, I know you live in Mariana, which is right on the border, but you handle cases exclusively in the state of Florida, correct?
Yeah, I'm licensed in the state of Florida. I try to stay within the 14th Judicial Circuit, Bay, Jackson, Calhoun, Gulf, Washington, and Holmes County. I rarely take a case outside of the 14th Judicial Circuit.
Okay. We now have another caller, Reed in Bay County. Reed, if you would, go ahead with your question.
Hey, Ted, thank you for taking our call tonight. My question's for Mr. Young. Mr. Young, I have a question about getting a divorce. My wife seems to flirt with her old friend from growing up that's married to her best friend. They sit around sometimes. They make me feel less of a man by talking down to me and other hurtful things. I heard where you said the resolution of marriage, 10, 20. We're just over 20 years. And you guys have any advice you'd have moving forward just to, is this normal kind of stuff you see in your practice? I'm going to hang up, Mr. Young, and I appreciate it. Thank you.
Well, Reed, that's a very interesting question. Right. One of the problems is, or the issues is Florida is a no-fault state, and being a no-fault state, what that means is that a party's conduct really doesn't have any bearing as far as the outcome as child custody issues. One of the things that could come into play is the courts can't take into consideration the moral conduct of the parties or the moral fitness of the parties in making a determination as far as what is in the children's best interest. So if your wife's behavior is inappropriate and is having an impact on your children, certainly the court will hear that in a contested hearing, and that will be one of the many factors that the courts consider in determining the ultimate outcome as far as awarding time sharing and developing a parenting plan is the moral fitness of the parties.
Well, that's a tough situation you got there, Reed. Good luck with that. Make sure you reach out to John Young or someone like him so that you can plan appropriately and figure out what your next steps are. We're going to take a break right now, but those phone lines will be open when we get back. Please give us a call at 850-392-1544, and we'll see you just after this commercial break. Welcome back to Law Call. Ted Howell and John Young Roberts here talking about divorce, custody, family law, you name it. Over the break, we had another phone call come in. If you would proceed with your question.
Yes, this is Jackie. I was calling concerning a situation my sister's got herself into. She's wanting to get a divorce, but when she bought her family home, bought a home with the money her parents left her when they died, her husband refused to pay anything on the home. He has not paid one dime. However, he said that if she didn't put his name on the deed when she bought the house, that he would not pay the electricity bill, the cable bill, the water bill, would not pay a dime for anything. And since she'd be using all her money for the house, then she would be up the creek without a paddle. Is that legal to do, or can that be filed in a divorce?
Okay, that's a difficult situation, Jackie. And I think, like you mentioned earlier, Johnny, you practice in Florida. So, Jackie, you definitely need to have her counsel with a lawyer specifically in Alabama on that. But as far as if that's in Florida, which is an equitable distribution state, how would those issues be handled, John Young?
Well, what happens in Florida, you have two types of property in a dissolution of marriage action. You have what's called marital property and you have non-marital property. Marital property is anything that was accumulated during the marriage as a product of someone's efforts. Non-marital property is typically anything that anyone owned prior to the marriage or anything they accumulated during the marriage that was not a product of one of their efforts, for example, like an inheritance. However, you can take a non-marital asset, like you were describing here, and commingle it and make it a marital asset. So the fact that she put him on that deed, if this would have been an asset in a dissolution of marriage action in Florida, she would have to commingle that non-marital asset, and even though he hasn't paid anything toward the mortgage or paid any of those expenses, it doesn't matter. If he is on that deed, now it's a marital asset, and it would go into the equitable distribution scheme, and he would be entitled to 1/2 interest of that asset.
And John Young, does it factor in that it was actually, it sounds like they're treating this as their homestead as opposed to rental property or separate property? Does that play into the commingling at all?
It doesn't matter. The deed would control.
Okay.
And so the fact that she put him on that deed, now it's a jointly held asset, and it is subject to the equitable distribution.
Okay.
So.
Well, Jackie, make sure and have your sister reach out to an Alabama licensed family law attorney, and if she has any difficulties, you can call our office and we'll make sure and put her in touch with somebody so that you can have that issue properly addressed. Now we have Stevie on the line, I believe, from Jackson County.
Yes. How you doing, John? This is Stevie. I'm glad to see you.
Stevie, good to hear
Russ.
from you.
You recognize my voice? Yeah, you remember taking my case and everything worked out fine. I got joint custody for my boys.
Yes, sir.
And they grown up now and everything and out on their own. And I appreciate everything you've done for me.
Yes, sir. Good to hear from you, Mr. Ross.
All right, and I'm just glad to hear and see you tonight on TV.
There you go.
Good seeing you, Stevie.
Stevie, do you have a question or you just have an attaboy? Sounds like that was just an attaboy for Mr. John Young. And it's always good to get one of those.
Yeah.
So good. So that was an old person from Jackson County. Yeah. But it looks like while Stevie was on the line, we got an email question that came in. My soon-to-be ex-husband doesn't want to show up for court. We filed an uncontested divorce with a separation agreement. If he doesn't show up, would that mean he only waives his rights, or would it mean the judge will dismiss the hearing? We're both self-representing, and that's K. John Young, how does that look in a default type situation?
Well, Kay, in Florida, you have to have personal service on someone. So if he was served with a petition for dissolution of marriage and he did not file a response, then the clerk would enter what's called a default. And depending on whether or not you have child custody issues, you still have to prove your case in court whether or not he shows up or not. You're entitled to a dissolution, whether he participates in the proceedings or doesn't participate in the proceedings. However, if there are minor children involved, you still have to go through testimony for the court to hear to make a determination on what type of time-sharing arrangement the court's going to enter and what type of parenting plan the court's going to enter. So long as he was served, if he doesn't choose to participate in those proceedings, you have an absolute right to move forward with your life, close this chapter, and move on with the next chapter of your life, and move forward with your divorce. So whether or not he shows up for a hearing or doesn't mean that the court cannot proceed.
Right. But they're still going to make sure whatever happens is in the best interest of the children.
That's correct.
So that's an overarching thing that you have in family law. For example, in a personal injury case, if somebody doesn't show up, liability will be established as long as you have the well-pleaded allegations in the complaint, and it's just a matter of how much do they owe. And now you still have to take testimony of that and establish your damages, just like in the family law arena. You still have to put on testimony and establish what is proper for that child or whatever the situation may be.
That's right.
And that's a question I get very often, John Young, is folks will ask me the question of, well, I want to leave. If something, God forbid, were to happen to me and my spouse, I want my sister to have them, or I want my dad to have them. Are those types of arrangements binding, or do they have any legal effect if I put something about my wishes for who would take my children if I were to pass away?
Well, a lot of times people, when they do a will, they will put in there who they want to be the guardian of the children or guardian of the children's property. However, if you have another parent out there, their rights are superior to anybody else's. Right. And so in the event someone passes away and they put in their will that I want my child to be taken care of by my parents or by my sister, but you have another parent out there, whether it's the mother of the child or the father of the child, their rights are tantamount to any third party's rights. And unless that parent is an unfit parent pursuant to the statute, then that parent would have custody of that child in the event there was a death of the other parent, no matter what you put in a will.
Exactly. So you don't, children are not property that you can just pass along.
Right.
I mean, you can give your guidance, but at the end of the day, the court is going to do an analysis to make sure that it's in the best interest of the child. You can't just decide you're going to leave them with Cousin Eddie, for example, and that's going to work.
But now, if you have parents that are going away on a trip and they're afraid that something might happen, whether the plane crashes or you can imagine another scenario, those parents oftentimes do a will, and they will set forth in that will who they want to be the guardian, and the courts give a lot of deference to that legal document that was signed by the parents prior to their passing. So.
Right. And because with the thought being that these people would be someone that the parents know, they trust, they know their kids, they know how that dynamic's going to work out. So I can see why the court would get that deference, but also if some people don't make the best decisions, the court's going to second guess that. They're going to look behind it. They're just not going to take it all the way to the finish line if for some reason it's not the right decision. We still have those phone lines open. We have a few minutes here left, so 850-392-1544. Make sure and call us if you have anything. You got your last little time here with John Young Roberts. You want to make sure and get that question in, get it answered. Or if you have another attaboy like Stevie that you want to call in and give, that was very nice as well. Yep.
And I will say, I'd like to take this time to say hello to my mother, Catherine Roberts, in Mariana. She asked me to give her a shout out tonight. My mother always wanted me to be a preacher. Mom, this is as close as you're going to get. And also Brooke Cummins. I've got a very sweet niece that she loves watching this show. And I doubt she'll call in, but Brooke Cummins.
We're a little early on the shout outs, but you can go ahead. You might, your mom would have been upset with you if you'd have missed it. Hey. So we know you got it in there, and we know that we got you set no matter what.
I'm good.
You have checked that box. But with respect to guardianship, if you do have to set that up, I mean that's something that you have to go through the court systems as well to do. You can't just actually do that with a written document.
Well, guardianships, there are a lot of checks and balances because, if parents have life insurance and they leave life insurance to their children upon their passing, the courts want to make sure that whoever is their guardian is using that money for the benefit of the children, whether it's college expenses or purchasing a vehicle or orthodontics. They just don't have an open checkbook with that life insurance benefit to spend it how they want to. So you still have to go through that, and there's to file annual reports and for the courts to make sure that the guardian is taking care of the child, or they call the ward, and using that money for their best interest.
Very good, very good. Well, let's go ahead and take our final break of the night, and we will be back just after these commercials. Welcome back to Law Call. Over the break, we had another phone call come in. If you would, go ahead with your question, please. Pat?
Yes, I wanted to know if I had let someone use my car and someone hit them, and the person that was using my car did not have license. And now they're saying that because they didn't have license, even though the person hit them and had license, that they don't have to, and they totaled my car, and they said they don't have to pay.
Yeah, Pat, that's a difficult situation, and you have responsibility when you let someone use your vehicle that doesn't have the proper licensure. So unfortunately, that's going to be a situation where you're unlikely to have coverage under your own policy, and unless the other person was responsible for the accident, you don't have an avenue to recover there. So just as a general rule, make sure you know that someone is not only a good driver, but actually has the legal requirements to drive before you let them borrow your car. And I'm sorry you're dealing with that. Now, John Young, is a time in our show where we actually do the shout-outs. I think, did you have any more that you need to get? You better give a few more.
I had a text, a client text me and wanted to know, and this is from Jackie from Mariana.
Oh, yeah.
If you have a claim against the Department of Transportation, does it typically take longer than normal to settle that claim than other cases?
Absolutely, because anytime you deal with a municipal agency, you have to go through a notice of claims process, and they are the government, so they're going to do everything they can to keep the process moving at a slow pace.
Gotcha.
But thank you, Jackie, for calling in and asking that question, or texting Mr. Young. That way you got it in here. I have just a couple real quickly. I saw Miss Cheryl Stubbs was watching tonight. Thank you, Cheryl. Libby and Tommy Martin, two big Law Call fans, and my paralegal's parents. Good tonight, y'all. And then Marty Harp as well. That's my other paralegal's mother. She's doing well. And then last but not least, Gary Starr. Gary, get better. We love you. Hope everything's going well. That tells me I've run over my time. So, oh yeah, we have a couple pictures. Real quickly, this is my father-in-law at his 80th birthday party and his whole tribe there, wife and daughters. And then one more picture, I believe. That's Miss Catherine Roberts and John Roberts. That's John Young's parents there on the picture there. And last but not least, this is Miss Patricia with Larry. She was kind enough to take a photo with him and got herself on the Law Call tonight. Patricia, hope you were out there watching us. Next week, we're going to be back with two from Perry and Young, and hope to see you. Good night.